At this point, we'll call the third case on this morning's docket and allow everyone a little bit of time to turn around and get into their places. That third case, also from Wyandotte County, case number 128644. Amy Whitney, on behalf of herself and other similarly situated appellant versus the University of Kansas Hospital Authority, appellee. Would the parties please state their appearances?
Jake Miller and Barry Grissom on behalf of the appellant Amy Whitney and others similarly situated.
Good morning, Lauren Tucker McCubbin on behalf of the defendant appellees, University of Kansas Healthcare System and its employee-sponsored benefit plan.
Thank you. And Mr. Miller, would you like to reserve any time for rebuttal?
5 minutes, please.
5 minutes are granted. You may proceed.
May it please the court, Jake Miller on behalf of Amy Whitney, appellant in this case. This is a simple breach of contract case. The Supreme Court has already held in this kind of contract provision is a litigated case under the Town decision. The Town decision in this case went back and said that self-funded plans could not subrogate against others, right? So the appellees in this case have stated that there's no retroactivity issue here, or that retroactivity should not apply. Well, we find that the only argument here today, or really the only question to the court is whether retroactivity applies or not. Okay, that
help me though. In the process of this case, your client had already agreed to pay the subrogation.
Yes, but that's the same as what happened in Towns. Towns also paid the subrogation.
Your case was concluded before Towns was handed down by the Supreme Court.
We didn't have a previous case.
Well, your cause of action was concluded. Your client agreed to pay the subrogation expenses back to the hospital, right?
Under a contract of adhesion, but yes. Which is the same.
I'm not here to argue about it. I'm just trying to get the facts. So your client agreed to pay back the sum of money under subrogation.
Yes.
It was a negotiated settlement, right? It was less than what was initially.
Not for Miss Whitney. For her husband it was, but not for Miss Whitney. Not for Amy Whitney. And the reason I answer it that way is because in Town, the Supreme Court noted regarding their subrogation that it is a breach of contract claim within the policy if we're going to subrogate monies under a contract provision that we find unlawful. That is specifically what the Supreme Court said in Town and allowed them to actively apply to the previous 5 years for anyone who fell within the statute of limitations. The general rule here on retroactivity and application is whether or not how a new case is implemented. This wasn't an overruled case. The appellees like to state that the Supreme Court overruled Sloan. That's not it. They did overrule Sloan, but they start with saying that the plain language of the statute and the regulations say that it is meant to protect employees, not employers, and they never understood why anyone would ever deem it as an employer. And Sloan was a Court of Appeals case, not something that went to the Supreme Court, and the Supreme Court noted that nothing was should have been set as precedent in this case until the Supreme Court actually heard that appeal in Towns when they overruled it. So it was not.
So Sloan had no effect?
On.
Be careful, counsel.
Well, no. I'm not saying it had no effect.
Because it was the law in place for 30 years.
It was, but the Supreme Court noted that this was the first time they were interpreting the statute. This was the first time they were ruling on it. Sloan was governing at the time, but they're saying that it wasn't merely an overruling of a case. It was the plain language of a statute that was being applied. So it was not a new law that was being issued. It was a new interpretation that was being governed there.
Counsel, I want to go back. You said that then the Town decision could be applied. I think you said retroactively to 5 years preceding that decision. But that just means that anyone who hadn't filed a case up to that point who had a live case under the statute of limitations could file an action and would have the benefit of town as the decision that was then the governing case law. That's no different from any other decision, is that?
Well, and that's what the Supreme Court speaks to in Hall. Our case was within that time frame. Our case was within the statute of limitations.
But the difference, at least in my view, the difference seems to be that the case, could have been brought, but the case was settled and final, or the dispute was settled and final before town. So it, that case could have been litigated, but it wasn't. It was settled and final. Does that mean that any case that was settled and final within that period gets the benefit of a decision that's handed down potentially years later?
I would say yes, and I'm going to answer your question twofold, if I may. First, the facts here are no different than town. Town also settled his case. Town also negotiated a settlement that went. If that were the case, if we weren't saying if we were saying that was a settled case, then they wouldn't have been able to apply. Then the Supreme Court would have kicked them down for saying, you don't have a case. You settled a case. You negotiated a claim. You paid back a subrogation. That was all done in towns. It's actually noted in the opinion that they reimbursed the plan, because under these plans, I can't pay out my client who lost their job because of this, and the other was off for some period of time. I can't give them the insurance monies they've received until I've repaid the plan, right? So I don't have an option to sit here and say, let's litigate this and let's wait a couple of years and see what happens. We're forced for our clients' behalf to pay back those monies before we're able to give that money to our clients, right? So the second part of that is, and sorry, will you repeat the second part of your question? About
my question was, do we, under your argument, does that mean that any case that has been final during the 5 years before town was decided, that any of those cases can be reopened and relitigated?
I would say so, because under Steck-Schulte v. Jennings, the court has laid out, which is really the governing rule on retroactivity, has really laid out that it applies to cases pending on appeal and also future cases. Now,
right,
future cases is not defined as an injury that occurs after the opinion is decided. Future cases is seen as a case that could still be actively litigated, a case that could still be filed. Miss Whitney is within her 5-year statute of limitations. That's why.
Do our rules of preclusive effect not have any effect in that regard once a case has gone final?
I would say that if it would, then in fact, under the doctrines, it talks about an actual judgment that's been filed and verdict that has been filed. Those are the two that cannot be appealed on a retroactive position. If there's a verdict and a judgment out there on it, neither of those exist in this case. A simple us mailing a check in to pay a lien off is not, to me, something that could be there. And to that point,
So let's take this a little bit differently. Let's take town out of it. I want to talk about a few years ago, there was a cap on non-economic damages that was for $250,000. That cap has been moved and now held unconstitutional in some respects. If cases were settled before that cap changed, say for $250,000, because that's what they thought that the cap would be, does that mean that all of those cases, upon the change in the law, that all of those cases can be relitigated under your analysis?
I would say it depends on that settlement. Was it an active court case that then had some sort of a stipulated dismissal, which would be considered a verdict? Or was it something that was a settlement document that was signed by the parties? Neither of those apply in this case. There was no settlement document. There was anything.
Well, there had to be something for you to pay them money.
They sent us a lien and said, mail us a check. Those
And
were
you
listed.
negotiated the amount, right?
We attempted to. It didn't. to that, I want to speak on something there. After the work on this case, KU actually filed a lawsuit in Leavenworth County against our clients to recoup monies for what they were saying was money owed under one of the previous liens in Leavenworth County. And so I find that very interesting because we were able to, we counterclaimed it, we fought it. It was a debt collections. KU says, well, one hand wasn't talking to the other. My point on that is if the analysis of the court is that a contract was binding and a contract was settling, why did KU ever file that lawsuit? KU doesn't file that lawsuit in Leavenworth County if they believe they had a final binding contract, a final binding settlement. It wouldn't have existed. So that actually happened later after the case had already started.
Is that part of the record, counsel?
It's not part of the record because it happened after. I do have the case number that I can bring up on rebuttal if you may.
Is that an ongoing case?
No, when we pushed back, the debt collection attorney backed off, and we finalized it that way.
It strikes me that it's perhaps an interesting anecdote, but it's not something that we can take into account. It's not part of the record on appeal.
And I understand that, and I'm not trying to do it for that mere case, but I find it interesting that KU wants to argue that there was this contract and we had this final negotiated settlement, but then they're able to go back and sue, but we're being told we can't from their perspective. That's really the perspective I'm making there.
Counsel, I see that we're at the end of your opening argument time. Are there any other questions from the panel? No? All right, thank you very much. You still have your rebuttal time.
Good morning, Your Honors. May it please the court. As the panel's questions during the appellant's arguments made clear, the relief that the plaintiff is seeking in this instance is the broadest retroactive application of the town decision that could possibly obtain. And that broad application is not one that has ever, to my knowledge, been applied by a Supreme Court or a Court of Appeals in the state of Kansas. They're not asking for retrospective application or retroactive application to the parties to the town case. They're not asking for retroactive application of the decision to parties who had cases pending at the time that town was decided. Instead, they're asking for retrospective application to anyone who is adversely affected by the allegedly adversely affected by the subrogation that was obtained by the plan against their third-party tort recovery. None of the cases plaintiffs have provided this court have reached that conclusion. Every case they have provided with respect to retrospective application has limited such application to the parties to the litigation in the overruling case and parties who had pending lawsuits at the time. The standard for determining whether or not, even assuming this court were willing to branch out and adopt the first of its kind general retroactive application, the standard is not the rule for prospective only cases that is described by the plaintiffs in connection with the Unruh decision. Instead, it is the factors that are laid out in the Sharp case and the Vaughn case. And under those factors, it is clear that what the relief the plaintiff is requesting is inappropriate. Specifically, in courts considering whether or not to apply cases retrospectively, evaluate a number of factors, including reliance on the prior law. Here, there is no dispute that there was 30 years of parties, including the plaintiff and defendant, relying on the Sloan decision as the binding legal authority that permitted the plan to subrogate against third-party court recovery. Courts also look at the adverse effect of a retroactive application. This court is obligated, as the plaintiff has stated numerous times in its brief, to accept as true the well-pleaded facts in their petition. Plaintiffs, while seeking to represent a class and pursue the claims on a class-wide basis, have pleaded that there are an unknown number of people who might be affected by a retrospective application as they request. This means that there could be hundreds, if not thousands, of lawsuits that arise if this court retrospectively applies the town decision to the universe of people who may have been affected by subrogation over the period of time that was permitted pursuant to Sloan.
Ms. Tucker McCovey.
Yes.
Can I ask you, I mean, at the most base level, the language of the law did not change. And so your position is that this was a new law, or that town created new law. And then once we get to that, then we get to, whether it should go prospectively or not. But the fact of the matter is the actual language of the law never changed. And as opposing counsel stated, this is just simply a different interpretation of the law. And it's the first interpretation by the Kansas Supreme Court. So how do you overcome that?
Well, we first dispute plaintiff's contention that this is not new law, obviously. However, it's not we don't have to make that finding to avoid the type of retrospective application that the plaintiff is seeking. That standard, the new law standard, only applies when the argument is prospective only. So here, for example, this court could decide that the town court's opinion applied prospectively to new cases filed and arising after the town decision, and the party litigants to the town case themselves, and anybody who had a case pending at the time. That finding does not require or does not necessitate you to conclude that there was new law resulting from the town decision. That standard is only required if we're seeking prospective only application. The other remaining factors that are described in Sharp, frankly, argue in favor of not applying the broad retrospective application that plaintiffs are seeking. And we discussed that at length in our brief. But nonetheless, it is our position this is new law. For 30 years, the parties were operating as though this was, crystally clear, permitted because of the Sloan decision. Also, it was an integral part of the contract between the plaintiff and the defendants. In the record, you can see in the plan documents, it describes how the right of subrogation is a vitally important component of an employer-sponsored health plan. What it does is it permits the plan to offer benefits to the largest majority of participants because it protects the cost of operating the plans from increasing. What plaintiff is asking is to create a special class of individual members of the plan who happen to have been injured and happen to have needed medical services by virtue of third-party tortious conduct. And plaintiff is advocating that those folks should get preferential treatment and be able to recover twice, once under the plan and once from their third-party tort recovery.
Counsel, it sounds like you're wanting to relitigate town.
I don't know that we need to, Your Honor, because I don't think, as we've argued, that it applies retroactively. But, would my clients disagree with the outcome? Yes. We think it inconsistently decided the case with the legislature's intent, which the legislature clarified by enacting the House bill afterwards. And while we don't need to relitigate town today, we can take into account the adverse impact on the plan participants who are not in this special subset of folks, because those are the people that will be harmed if the retrospective application is permitted. They will be the ones that will be subject to having less money available in the plan to cover all of their health insurance benefits by virtue of potentially having to return monies that were obtained through subrogation.
But we don't typically decide whether something is prospective or retroactive based on kind of policy decisions as to who it's going to be affected or who's going to be affected by that decision. Instead, we just decide, based on these factors, is this decision one that should be applied broadly to all cases? Or is this a decision that is just applied basically going forward to the current litigants and to other litigants who are in the process of arguing their case or going forward, right?
Well, I don't disagree with your characterization entirely. I would just point out to the court that the factors that are cited in the Sharp case include the nature and purpose of the overruling decision, the party's justifiable reliance on the law as it stood before, the vested rights of the individuals who are involved in pursuing subrogation, and the adverse effect on the parties and the administration of justice in the event that the case is retroactively applied. So I think it does permit this court to consider the adverse effect on the parties who are harmed by the retrospective application of the town decision. In short, our position is the district court got it right, but you with your unlimited review are entitled to apply the factors in Sloan and reach the same conclusion, or alternatively find that the opinion should apply prospectively only. We believe that this court should affirm the district court's grant of our motion to dismiss, and we appreciate the court's time. There are no further questions.
Other questions from the panel?
So.
All right, thank you. Council, I believe you have 5 minutes that you've reserved for rebuttal.
Thank you. And I'll briefly touch on some of the statements made by opposing counsel here. When we look at the perspective only application question and whether that is deemed there, when the Supreme Court has used perspective only application, they've listed it in the decision. They've explicitly said this is a perspective only application of the law. This is only going to affect others.
They did not do that here.
And they did not do that in town. So for it to really only apply prospectively, why wouldn't they have said it here? And I think that's the crux of a case here. The district court erred when they ruled on this because they believed that silence meant prospective only, but there's nothing in years of case law that says prospective only application is the general rule, is what we default to. So I note that, and actually within Hall, Casco is cited, which changed was a different interpretation of a workers' compensation law. And in that case, when it was the first time on appeal for the Supreme Court, they interpreted a statute for the first time ever. They even noted within the appeal, and as it's noted in Hall, it did not establish a new law and was not limited to prospective application, which is what was applied in Hall to then go back and predate using essentially stating injuries that occurred within that statutory time frame. If it was still a case that could have been litigated, it could have been and should have been and would apply to the new Supreme Court ruling. I would also note that in Schulte, there's a couple factors that we see as they come down, and we see in Appellee's brief how they argue against it and saying that the court dismissed the two arguments in Schulte. But before the court ever got to that point, they noted that the application should still go to cases pending on appeal and also future cases. Now, I will agree with the court that there's not a very clear or dictionary definition of what a future case would be. I think we are running into issues of straining interpretation of what would mean within the statute of limitations to limit people who actually have a case that they can still be brought. Now, I'm not saying that the court should allow filings from 20 years ago. And in fact, I think
Are you arguing then that every single case that involved a subrogation lien over the last 5 years can be reopened?
I think that the town's court spoke to that. They said
Once those cases have gone final. So all those cases that have gone final between 2000 and when was town? So
24.
Yeah, so from 2019 to 2024, all of those cases that were settled, all of those cases that were litigated on the merits and went final, all of
No.
those cases can be reopened?
No, because under the rules of how the Supreme Court applies those through retroactivity, anything that has a final judgment, anything that has a verdict attached to it is done. They say that. There's nothing that says that a settlement would not be done in that case. And I think it's even a stipulated dismissal or something of a case that's settled within court, I believe would be deemed as having a verdict, so that couldn't be relitigated. But the subrogations that happened within those 5 years, yes, I believe that applies as a future case because you have it. Now, I would argue that it's from today's date back to 5 years. Those cases could have gone with towns, but if it was a mid of 2019 years, they'd be out of the statute of limitations now. I note that because in the motion to dismiss, there was some questions raised by appellee, but that under our interpretation, we'd be saying we could go back 30 years to relitigate every case, and that's not what we're saying. We're saying cases that can still be litigated that are within the statute of limitations would require us to be able to utilize them. And I state that because if the court didn't want us to handle it that way, then they would have applied prospective only application as they have done in Carroll v. Kittle and many of the other cases that the appellees cite. They specifically list prospective application. They did not do so here. And I would, to the further point, I want to bring up the legislation over just a couple seconds that was pushed by the defendants here. If the legislature intended for it to not be retroactive, they would have made that statute retroactive. The legislature can always make a statute retroactive. They did not. They made it pursuant to July 1 of 2025. If they wanted that to be retroactive and say, this question isn't for the court, here's our intent, they could have gone back and said, Towns was wrong. We're going to make this so that it's from January 1 of 2024. They didn't. As we're fully aware, the legislature can always make a statute retroactive.
Well, within reason, there are
Within reason.
limitations on that
Within-
ability.
Within reason, but even if they had said January 1 of 25, something, they didn't put any retroactivity in their statute whatsoever. So I note that because we're talking about legislature's intent. I don't think the legislature intended for any of that to happen until after July 1 of 2025. So thank you.
Opposing counsel talked about potential economic harm to current plan participants. Should that factor into the decision that we make?
I don't think so, because when we talk about unjust and hardship, first off, any of those decisions could have been made by allowing us to make it through a pleading stage, right? This was kicked out on a motion to dismiss and not further down the road on a summary judgment or something, because how many plan participants have been affected by subrogation? How many plan participants are in the same situation as my clients that could have been recovering money? They could be it'd be placed in a worse position than even that plan. And quite frankly, I think that's the hardship and injustice that's being applied. Does that answer the question?
I think so.
If there's any,
Questions from the panel? Would you like to close or are you finished?
I've taken enough of your time, so thank you.
All right. Thank you very much. Thank you, counsel. We'll take the matter under advisement. I want to thank you for your excellent arguments and for your excellent briefs. We'll get a decision out as soon as we're able.